So this video was requested by a number of people who have subscribed to Lawhero.eu. So first things first, being strategic and looking at the company law syllabus, I would say, looking back at past exam papers and what he is asked, he being Tom Courtney, I would avoid question on the reform under the Companies Act 2014, simply because now we're at 5 years after enactment. Practitioners are well used to the Act now. The second thing as well I've noticed by going through the papers is there's definitely a trend towards insolvency practitioner like questions, for example, liquidator, receiver, examiner. So definitely have at a minimum your liquidator and your receiver question ready. I have a feeling that he might ask examinership in 2019, simply because there has been a lot about it in the papers. Apparently only 2% of insolvent companies will use examinership. I would say become very, very familiar with your act, have it tabbed, know where the sections are, highlight the sections you're going to be relying on in the exam. I'm talking about section 38, section 40, section 95. I would also have section 239, 238, connected persons, section 202, the kind of sections that you need for most of your questions. So as everybody knows, I'm very much against learning off answers, and what I've done on Lawhero.eu, firstly for company law, because it's the first FE1 subject I've tackled, is that I've put up 8 subjects or 9 subjects under the topic of company law, which I believe will cover you for every company law exam, rather than saying here's an answer on director's duties, learn it off. Doesn't really work like that. So the first question on the October 2018 company law paper was a question on directors' fiduciary duties. This is such a lovely essay question to get, because you can basically just ream off as quickly as you can. Now question 2 seemed a little bit trickier, but it actually isn't. So it was a problem question on receivership. So it involved a receiver being appointed on the foot of a debenture. I think the debt was 2 million. They have an asset which they acquired in 2007 for 2.5 million, but now it's only worth about 1.5 million. And then he throws in a little bit like that the asset is a factory that's involved in making coffee, and he throws in a little bit there about, like, you know, it looks like he's getting at an ROTC chart, but he actually isn't. So don't get caught out. Just know what he's asking here is receivers' duties to the company, and also then there's a guarantor who's actually a director of the company. So basically you just have to remember that the receiver's duty is always to the company, and the receiver has a duty in law to get the best deal possible at market value for the asset at this point in time. He doesn't need to worry about down the line. So somebody says, yeah, I can give you 2 million now, but if you wait a year I can give you 3 million. He's not bound to rely on that. He just has a duty to take what is the best price he can get for the asset now. And then the other part of the question, which Courtney alludes to, is duties to a guarantor. Just remember that receivers have no statutory duty to a guarantor, but remember, if there is a shortfall in the amount that is received for the asset as against the outstanding debt, the guarantor is going to have to make up the difference. The third question is an essay question on corporate authority as opposed to corporate capacities. Just remember the difference between the two is corporate capacity is what the company can do, and ultra vires and all of that, which has now been taken out by section 38, because limited companies have full and unlimited capacity like a natural person to act, subject to their constitution, and obviously not doing anything illegal. And then section 40 looks at the persons who are entitled to bind the company. And actually under section 232 and 233, 233 caveats 232, which means if they've acted honestly and responsibly. It looks like here they haven't when it comes to keeping the book of account. that they actually can be made personally liable and account to the company and indemnify the company for the loss which has come out of them not keeping proper books of account. And if the situation was bad enough, which it is here, the director could definitely be restricted by the liquidator, and actually the liquidator has a positive obligation to bring a restriction order if the company is insolvent, which it is here. So the next question is a question on section 819, which is a restriction order. It's just an essay, and it's actually, again, quite easy because you can just go through the case law and explain what the order is. So the order is at section 819. Section 820 are the people who can actually bring the order. And then you would just go down through the case law, and these are cases like re Gasco, re Lowline, and re Squash, which look at like different nuances as between, is it the way the director behaved in the last 12 months or is it over his tenure as a director in the company. So question 6 is a problem question on distributable reserves and the obligations and liabilities on directors and shareholders if they pay out a dividend and there is not sufficient distributable reserve. People don't like this question and it's very poorly answered, and actually not many people answer this question. So I think if you know this well and it's very straightforward and you want to get the examiner on board, I actually would learn this in my company law ebook. It's in the directors section. It's also in the shareholders section because it applies to both. There's a positive duty on both. So the 7th question on the paper is about section 212, which is oppression of a minority shareholder, the rule in philosophy Harbottle, which means that the company is the proper plaintiff if the company has lost out somehow, and then the exceptions to the rule, which can include a derivative action. So basically what this means is all of these three combined will prevent an errant director doing something which is not in the best interest of the shareholders. There can be a situation where you're a minority shareholder and the majority have passed a resolution and you don't think it's right for the company, or it's you as against your fellow shareholders who are having the argument. Depends on the situation. So the final question, question 8, is again a petition which has been brought by the revenue commissioners like the previous question we had, and your job here is to advise the liquidator. So you're provided with some information. You're told that it's a timber company and that there is a retention of title clause over some of the assets, and then in the B part there's also a fixed charge on the account. So it seemed here that the company had a certain level of control over the book debts because they were placing them in the account and taking them out, and that would kind of give rise to the fact that it was a floating charge because of their control over it. So even though they were using the designated bank account, it seems to have been a floating charge here, even though they called it a fixed charge in the deed. So I hope that was helpful. Again, it was requested, and I really want people to request videos because this is all for you guys, it's not for me. And I think that the company law paper, which will be asked next week, March 2019, will definitely deviate from what was asked because that's what he tends to do. I'm just going to throw it out there. I think that he might ask examinership. And also I think, you know, you need to know your director's duties back to front, and you need to realise that in most of the questions the situation is going to be that of liquidation, and then you have to navigate and advise the liquidator how to behave in an insolvency situation, because that's when people need help, is when the company is insolvent, i.e. they're not able to pay their debts as they fall due, rather than when things are going well. So best of luck to the exam. Best of luck in the exam for everybody's doing it. Please check out the Instagram at Lawhero.IRL, and also the website Lawhero.eu, that has all the notes up on it. And please like and subscribe. Thank you very much for watching.